In this presentation, I will argue why the appellant in the Rashid case should be allowed to have an intermediary for the entire duration of the trial. My main arguments are: number one, the courts recognize that a defendant has a right to an intermediary, especially because of his medical conditions. Number two, the court's approach prior to the Rashid case focuses on Article 6 of the European Convention on Human Rights, ensuring that the defendant has a fair trial and effective participation. My third argument will evaluate the current and new position of the court, which focuses on trial management and competent legal representation, and how this undermines Article 6 and how it is not enough to assist the defendant in court. I shall conclude by arguing that the Supreme Court should adopt the approach of the previous courts and thereby allow the appellant in Rashid case full use of the intermediary for the entire duration of the trial. Firstly, David Wurtzel argues that by 2008, the courts began to order the use of intermediaries for defendants under their inherent jurisdiction. This is evident in multiple cases. For instance, in the Crown against Sevenoaks Youth Court, Justice Openshaw stated that C needed someone to befriend and help him, both during the trial itself and in preparation for it. In short, he needed an intermediary. Similarly, in the Crown against Great Yarmouth Youth Court, Justice Mitting argued that there is a right which, in certain circumstances, may amount to a duty to appoint a registered intermediary to assist the defendant to follow the proceedings and give evidence. These cases illustrate that the courts are willing to assist the defendant and make arrangements for him due to his learning difficulties. Furthermore, this is supported by the notion of the principle of humane treatment, which states that the court should deal with the defendant in such a way which has best regard for the welfare of the defendant. In the Rashid case, the appellant has verbal comprehension index valued at 70, has impaired functioning on the working memory index, presented himself as more able than he actually is, and IQ valued at 65 to 70. Based on the courts recognizing the use of an intermediary for a defendant with learning difficulties and the notion of humane treatment, the appellant should receive the use of an intermediary for the entire duration of the trial and not just when giving evidence. This leads me on to my second argument, that the court's approach prior to the Rashid case was to ensure that the defendant had a fair trial and effective participation. This was achieved by making special allowances for a defendant with learning difficulties, most likely through intermediaries or its equivalent. For instance, in the Crown against Sevenoaks, although C was fit for trial, it was argued that he would have great difficulty because of his ability to concentrate, take in large amounts of information, and challenge the evidence would be limited. To help C participate more effectively in the trial, Dr. Mario argued that he might be assisted by an intermediary who could speak to C throughout the trial, and the judge conceded to this point by stating that if C is to have a fair trial, then he must have the help of an intermediary so that he is able to participate properly in the trial. For this reason, the appellant in the Rashid case, who also shares similar learning difficulties to C, should have an intermediary for the entire duration of the trial so as to ensure better participation. In the Crown against Great Yarmouth Court, it was argued that S would benefit from having access to a registered intermediary, as a registered intermediary would help S overcome difficulties in understanding complex questions, ensuring that questions asked are simple, having adequate time to respond, and the intermediary could alert to the court the difficulties that the defendant faced in answering the questions. It was argued that without those precautions, the risk that S would not receive a fair trial would be real. This case shows the principle of humane treatment enforced by protecting the defendant from psychological pressure when questioned. The appellant in the Rashid case should be afforded an intermediary for the entire duration in order to protect him from the psychological pressure of the entire trial procedure. Concluding my second argument, the Supreme Court should adopt the approach of the courts, which focus on assisting the defendant in as much as they can as possible in order to have a fair trial and effective participation. Limiting the role of an intermediary to only when giving evidence isn't sufficient, as the appellant could struggle to understand the dialogue between judges and advocates when he's not giving evidence, as well as the remaining court trial procedure. Laura Huyeno supports this view by arguing that if a defendant cannot understand questions in the course of his testimony without an intermediary, it is highly improbable that he will follow the trial without specialized assistance. This leads me on to my third argument, that the new approach of the court seems to limit the use of intermediaries and undermines Article 6. The Court of Appeal in Rashid is wrong to assume that trial management and competent legal representation is enough to help the defendant receive a fair trial and is enough to assist the defendant in the court. In the OP case, Lord Justice Rafferty said in regards to a defendant intermediary who would provide assistance throughout the trial that it would involve great support, general support, reassurance, and calm interpretation of unfolding events, which could be achieved by an adult with experience of life. Wurtzel argues that the Rashid case, in approving this point, goes even further by stating that to ensure the defendant gives best quality evidence, participates in his trial, and has a fair trial, in majority of cases, competent legal representation and trial management will provide this. For example, in the case of the Crown against Cox, it was held that it wasn't necessarily mandatory for an intermediary to be made available, as judges could deal with communication problems faced by the defendant. However, the following are reasons which outline the weaknesses of the new approach and the Cox case example. The weaknesses of the new approach are as follows. The new approach of restricting intermediaries does not function better than the previous approach, as it suggests that a vulnerable defendant needs an as it suggests that where a vulnerable defendant needs an intermediary, he is not entitled to one if he can have a good enough trial. In addition, the principle of humane treatment is being undermined by the new approach, as the focus is no longer on the individual, but rather on what is convenient for the court and the trial to proceed. The weaknesses of the Cox case example are as follows. The Cox case shows that where an intermediary is prevented from helping a defendant, Hoyeno argues that this diminishes the pool of expertise available to the defense, which in effect raises the issue of inequality of arms. Moreover, in the Cox case, it was noticed that the absence of an intermediary played a part in the decision by the appellant not to give evidence. This shows that if a defendant struggles to give evidence if a defendant struggles when giving evidence without an intermediary, he will most likely struggle throughout the trial without an intermediary. In the Cox case, the judge argued that to ensure C was not unduly stressed by the proceedings, he would have to be more interventionist than normal and play part of the role which an intermediary would otherwise have played. However, a feature of the adversarial trial is the principle of impartial or passive judge, that judges should not get too much involved during the trial. The argument here is that if a judge intervenes to assist the defendant, it could have a negative impact. The judge might intervene to relieve the stress, but perhaps by doing so it has the opposite effect of causing stress, which could mean that the defendant may struggle throughout the remaining trial. Similarly, in the case of Seven Oaks Youth Court, it was argued that it was unlikely that the kind of assistance that D needed in that case would be provided by a lawyer, and therefore an intermediary should have been appointed. Furthermore, the appellant should have an intermediary for the whole trial, as he not only assists him but also helps the counsel how to deal with the defendant as their client. Wurtzel agrees with this by arguing that an intermediary is more than what Rafferty seems to suggest in the definition. He provides ongoing assistance. He recommends how the trial process can be adapted to take account of the defendant's mental, physical, and emotional state. And he can assist experienced lawyers on how to communicate with witnesses and defendants whose difficulty he has not encountered, but the intermediary does understand and does know. Another feature of the adversarial trial is that inequality of arms is mitigated by free legal advice and representation. This suggests that the accused can effectively participate in the proceedings and can secure advice and assistance through lawyers. However, this may not be sufficient, as the Law Commission in its report on fitness to plead shows that intermediaries not only have specialist expertise, but they have specialist qualification and experience in assisting people with learning difficulties. In fact, an intermediary goes further than judges and advocates by managing the defendant's mental state, as his role is akin to a treatment role. In conclusion to my third argument, competent legal representation and trial management doesn't help the defendant receive a fair trial and effective participation, as well as an intermediary does, as evidenced by the previous court case decisions. In concluding my presentation, the appellant should have an intermediary for the entire duration of the trial, based on the principle of humane treatment as shown by the court's approach prior to the case of Rashid, and the fact that intermediaries are more beneficial than the judges and advocates in helping the defendant in terms of Article 6, fair trial and effective participation.